Really, the intent of this presentation is to familiarize the viewers with the basic tools and also the rules of a cargo claim and subrogating on a cargo claim, managing a cargo claim. It's such a large area of law that going into the very specific areas would require a much longer presentation. We're going to start off with the Carmack Amendment. It's still largely referred to as the Carmack Amendment, which was originally enacted in 1906, named after the senator who was responsible for sponsoring the bill, which is Edward Carmack. The underlying purpose of the Carmack Amendment was to prevent carriers of good, common carriers of good that are moving goods for commercial transportation from contracting out of their own liability for the goods and for being able to set up something akin to almost a strict liability scheme, largely because of the uneven bargaining power between the shipper and the carrier, and also the superior knowledge that the carrier would have. Obviously, once one entrusts goods to a carrier, it is difficult for the shipper to know exactly what happened. The Carmack Amendment was recodified by the ICC Termination Act. However, there was little changes that occurred following recodification. You'll generally hear the ICC Termination Act still referred to as the Carmack Act, and I'm going to use that term throughout this presentation. But if you hear ICCTA, ICC Termination Act, really it is still talking about the same body of law. What Carmack applies to is interstate rail and motor commercial transportation of property. As we move into the COGSA portion of our webinar, we'll discuss that sometimes Carmack is not going to apply to both the rail and the motor carrier semi-tractor trailer transportation of property, but we'll address that issue as we get to it. The purpose of Carmack is to establish a uniform system of carrier liability that would provide certainty to both the carrier and the shipper by enabling the carrier to assess its risk and predict its potential liability for damages. What this means is that a carrier and a shipper needed one uniform set of laws by which their rights and remedies would be governed when shipments are being transported through different states. It would be very difficult to have a shipment of goods be subject to certain rules and regulations as it passed through each state, and so that was also one of the driving forces behind implementation of Carmack and now the ICCTA. When applicable, it's very important to know that when Carmack is applicable, it will preempt a shipper's state and common law claims against a carrier for loss or damage to goods during shipment. What this means is that your common law negligence claim, your common law breach of contract claim, all are going to be preempted, inapplicable, and Carmack will be the sole law that will govern these claims. One of the first steps that one should take prior to doing anything on a file when a Carmack claim comes in is to understand the parties. Carmack is a claim that is a remedy solely for the shipper against a carrier. And there are several different players that are involved in the common transportation of goods. For instance, a broker is a person other than a motor carrier that as a principal or agent sells, offers for sale, negotiates for, or holds itself out as selling, providing, or arranging for transportation by the motor carrier for compensation. The broker is in no way involved in the transportation of goods. The broker simply connects the motor carrier to the shipper. And because it is not a carrier, Carmack cannot be asserted against a broker. A motor carrier is a person providing commercial motor vehicle transportation for compensation. This is going to be your truck driver. A hybrid of the motor carrier and the broker is a freight forwarder. Now this person holds itself out to the public to provide transportation of property for compensation, and in the ordinary course of business assembles or consolidates or provides for consolidating shipments. The freight forwarder will assume responsibility for transportation from place of receipt to its destination, and it uses any part of the journey a carrier subject to Carmack. The interplay of these three different entities in Carmack can be important. For instance, as I had mentioned previously, Carmack is a remedy for a shipper against a carrier. A shipper cannot sue a broker in Carmack. Moreover, a broker often, if the broker has a contingent liability policy, can step into the shoes of a shipper and sue a motor carrier in Carmack. So this will be the first step you want to take when dealing with a cargo claim, is to know which of these three categories your particular insured falls in, and to assess the limitations or remedies available to your particular carrier. One of the most important things to do after you've identified who your insured is to provide notice. The notice requirement will be strictly construed. You don't have to do much for the notice requirement, but if the notice requirement is not strictly complied with, you can lose your entire claim. What a shipper must do when a loss is identified is provide written notice of the loss within 9 months of the date of delivery or the date that delivery should have been made. The notice must identify a specified or determinable damage figure. Once this notice is given, the first part of a Carmack claim and the time limits governing Carmack claims has been complied with. After receipt of a denial, if the motor carrier has denied the claim, after receipt of that denial, then the shipper has 2 years to bring a lawsuit. Now, for all intents and purposes, I tend to err on the side of caution, especially as an attorney who may be the third person to see a particular claim, and I typically will file a suit 2 years from the date of loss or the date that the shipment should have been delivered. And the reason for this is, as an attorney, I am never positive that every single document that made it to the insured or made it to the carrier made it into my hands. As a carrier, it also makes sense. Oftentimes the insured will be the first person to provide notice of a loss, and that insured may have received a denial. And if you don't have the very first denial, you don't have the date upon which your time limitations would begin to run. So it's certainly not necessary to file suit within 2 years of the date of loss, but out of an abundance of caution, I usually attempt to do that. Carmack, as I had mentioned, does establish what is known as nearly a strict liability scheme by which motor carriers are responsible for damage to cargo. Now, in order to bring a claim under Carmack and to establish the prima facie case, a shipper must establish 3 elements. Number 1, that the goods were in good condition at origin. When they were on the tractor trailer, when they were on the container, they were not damaged. They made their way onto the container intact. The second element is that when they arrived at their destination, they were damaged. And the third element is a specific or determinable amount of damage. Now, the reason why the law requires meeting these 3 elements is because, as we had mentioned before, the shipper is not there the entire trip. The shipper has no idea what occurred, how the damage occurred. So it makes little sense to require a shipper to prove how the cargo was damaged, just that it was in good condition when it left the shipper's possession and in bad condition when it reached its destination. Now, once the prima facie case has been established, the carrier has certain defenses to liability. These defenses are act of God, public enemy, act or omission of the shipper, authority of law, inherent vice. This is going to be if there is something inherently defective with the goods, so that they say, if we're speaking about food, so that perhaps the food entered the shipment overripe, and by the time it reached its destination, it had, during the natural progression of the transport, spoiled, but not that it, but to demonstrate that it was nothing that the carrier could have prevented. For instance, setting the reefer unit at too high of a temperature, and strikes or riots. One of the most litigated defenses is going to be the act or omission of the shipper. And what you see this come up in often is going to be a case wherein the carrier, the motor carrier, states that the shipper failed to properly load or pack the goods. Now, this is a relevant defense. However, there is certain arguments that one can take towards this particular defense. For instance, if the carrier could see that there was sufficient packing, or the particular shipment wasn't strapped down properly, the carrier would have a duty to refuse to transport the goods until that deficiency had been fixed. So you'll see that this particular defense to liability does come up a lot. It is litigated somewhat frequently. Here's a uniform bill of lading, and you'll see many of these defenses to liability reflected directly into the bill of lading. I'm not going to go through reading it word for word, but I just wanted to get this in there so that you can have a copy of it. Now, as we had mentioned, COGSA does establish a very favorable scheme for shippers wherein they can essentially have strict liability and don't have to go through the burden of establishing a negligence claim, which is duty, breach, causation, and damages. They simply have to show that the goods got on the on the transport in good condition, arrived in bad condition, specify an amount of damages. So in many ways, Carmack is a very shipper-friendly law. However, the limitation of liability in so many ways, what Carmack gives, it also takes away. So a fundamental principle of Carmack is that a carrier cannot relieve itself of liability through contract. We had discussed this earlier in the slideshow. The drafters of the bill were concerned that these contracts for carriage were almost the equivalent of a contract of adhesion, and it created unequal bargaining power. But what has occurred is, while a carrier cannot relieve itself entirely from liability, it can limit its liability to a nominal amount. So what you see in the majority of the bills of lading that are used commonly is that a carrier will limit its exposure for liability by including a limitation of liability for a monetary amount. This might be 50 cents per pound per shipment, even though the shipment is worth $70,000, $80,000. You might see something in the few $1,000s that the shipper can actually recover because of these limitation of liabilities. Now, in order for a limitation of liability to be valid, there are four elements that are generally accepted that must be proven. These elements are that the carrier must maintain an approved tariff rate with the ICC. The carrier must obtain the shipper's written declaration as to its choice of liability, give the shipper a reasonable opportunity to choose between 2 or more levels of liability, and issue a receipt or bill of lading prior to moving the shipment. What you'll see most often litigated in these limitation of liability cases, and whether it can be overturned or not, is whether there's been a reasonable opportunity to choose between 2 or more levels of liability. And that can often be something as simple as referencing in the bill of lading the carrier's tariff, wherein the carrier will list what the different levels of liability are. The Carmack Amendment continues to regulate the carriage of household goods. However, because of the consumer nature of household goods, the Carmack Amendment has been beefed up a bit to protect everyday people. Now, the carriage of household goods, generally what you're going to see this, you're going to see this in the context of moving companies. So for instance, I move from my house in one state to accept a job in another state, and I don't feel like loading up a U-Haul and moving my own furniture, clothes, etc. So I hire a company to pack it up, put it in a truck, and move it for me. I take a plane. The courts are quite subject the carriers of these types of moves to stricter scrutiny because you're not dealing with a sophisticated shipper. This is going to be your ordinary person, and so they're going to require additional protection to these particular shipments. So the household good carrier's liability option is codified differently than your normal shipment of goods. the default limitation of liability is going to be full value protection. So unless the carrier unless the shipper declines full value protection, the carrier is responsible for replacement cost value of the damaged goods up to the declared value of the shipment. The carrier certainly is allowed to do a released rate option, which would value household goods at 60 cents per pound, and thus they would get a lower shipment rate. But the fair value protection must be waived in writing, and this is where a lot of litigation will arise, whether fair value protection was waived in writing, the sufficiency of the waiver, and still the carrier will also have to comply with those four elements to have a valid limitation of liability that we discussed previously. So the full value protection is a default, but it does not alleviate the carrier of demonstrating that it complied with a proper limitation of liability by complying with those four elements. I'll just move this back quickly so that we can refresh what we were talking about. The carriage of household goods does continue to be regulated by Carmack, as I mentioned. There are just some additional protections afforded to shippers of household goods. So similar to your ordinary Carmack claim, the shipper of household goods must comply with the Carmack written notice requirements. Thus, the 9 months requirement of providing notice of loss. This 9 months runs from the date that the shipment was received, if the shipment was received in a damaged condition, or if the shipment was not received at all, for instance, it was lost or stolen, the date that the goods should have been received. The notice must be made in writing, although electronic submission is acceptable. It must identify the shipment, allege the carrier is liable for the loss or damages, and demand a specific dollar amount. These are all the same requirements for the normal Carmack claim. One of the carrier protections in a Carmack claim that is also a carriage of household goods claim is that the carrier must be alerted to any items that are articles of extraordinary value. Now, the reason for this is that oftentimes with personal items, personal goods, it's very difficult for the mover, for the carrier to determine whether something is high value. For instance, very expensive painting may not be readily ascertainable as something that is an authentic painting versus a very high quality reproduction. Therefore, if a shipper chooses full value protection of their shipment, the carrier can include in its bill of lading a place for the shipper to list items that exceed $100 per pound in value. What happens when this particular option is included in the bill of lading is that it places a duty on the shipper to identify and list high value items on that form and alert the carrier as to the fact that this shipment contains some very high value items. The carrier could potentially increase the cost for shipping the particular shipment, and if the shipper fails to indicate these high-value items, these articles of extraordinary value, then the carrier's liability will be reduced to $100 per pound for each item. As we mentioned, this may be something that is pennies on the dollar for a work of art that might be between 15 and 20 pounds, or a very expensive piece of jewelry, which might not even be a pound. So it's important for household goods, the ordinary consumer, to be aware of that. And as you are adjusting a claim and you see these articles of extraordinary value, you can gauge what type of recovery you may actually be entitled to by looking to see the bill of lading, looking to see if the insured did properly identify these articles of extraordinary value. I want to mention that I believe there was we did cut out a small part of the presentation due to time constraints. This was a lot to jam in, but the next slide that you have on your PowerPoint should be removed, as it belongs to a category on warehouse liability. At this time, I would also like to introduce our trivia question. As I had mentioned, the winner of the trivia question can have their choice of our Matthiesen, Wickert, and Lehrer books. So the trivia question that we're going to have today is, why is a tractor trailer sometimes colloquially referred to as a semi? If you want to submit your answer, we will contact the winner and inquire as to which choice of book they would like to have. At the end of the presentation, I will go ahead and give the answer to the trivia question. Okay, so switching gears a little bit, we're going to move to the Carriage of Goods by Sea Act, commonly known as COGSA. Obviously, the Carriage of Goods by Sea Act is quite a mouthful to be repeating over and over again. And this is going to be, I guess the name is somewhat explanatory. It's going to be claims that involve ocean voyages, international shipments in particular, although, as we'll discuss, recent changes in the way that goods are moved, namely intermodal, multimodal shipments, whereas a shipment might originate in China, come into a U.S. port, then be transferred onto a rail carrier, and then be picked up and moved by semi-truck, has actually resulted in COGSA being applied to many of these inland portions of a move, but we'll discuss that as we get further into the presentation. So the Carriage of Goods by Sea Act is actually a U.S. codification of an international treaty. The U.S. is currently party to the International Convention for the Unification of Certain Rules of Laws relating to bills of lading, which is commonly known as the Hague Rules. The Hague Rules were implemented by the U.S. With the passage of the Carriage of Goods by Sea Act in 1936. So this is one of several different treaties that are in existence right now, and so it is good to keep in mind that the COGSA, the Hague Rules, will apply to an international shipment which reaches a U.S. port. However, you may be dealing with a different international treaty if your shipment does not reach a U.S. port, such as the Hague-Visby rules or the Hamburg rules. So that's good to keep in mind if you, for some reason, do come across a shipment that does not reach the United States. But because I feel that For the most part, we're not seeing a lot of that. We won't go into detail as to the differences between these various international treaties that we'll save for a different day. So COGSA is intended to apply to international water shipments, carriage of goods between any port in the U.S. and the port of any other country. As I mentioned, this is an international shipment body of law. And as I had mentioned before, an express statement in the bill of lading or similar document can subject domestic shipments to COGSA, which as a practical matter, carriers often incorporate, making the Harder Act largely obsolete. The Harder Act was the precursor to COGSA. It was enacted in 1893 and required vessel owners to issue binding bills of lading and sought to preclude the practice of including all-embracing exceptions to liability. This is very similar to what you saw in the development of the Carmack Amendment. So it is good to know that this could apply in domestic water shipments, although COGSA now applies to international water shipments. Harder Act could apply to domestic water shipments, but for the most part, you see that in the bill of lading, even on these domestic water shipments, carriers largely go with COGSA, but it's something to keep in mind if you do have a domestic water shipment, that unless you see COGSA referenced in the bill of lading, your Harder Act would probably be the default. So the general rule is that COGSA covers only from the time when the goods are loaded to the time when they are discharged from the ship. This is a term that's generally referred to as tackle to tackle. As we discussed, with the rise of intermodal shipments, multimodal shipments, carriers desired to have one set of law govern the shipment from origin to its final destination. And so what you'll see in many cases is the bill of lading, the contract of carriage, will include a provision known as the HIMALAYA clause, which extends the application of COGSA prior to loading or subsequent from discharge of the ship, which means that on these land legs of the shipment, COGSA can be incorporated to govern even the land transportation of the entire shipment. Under COGSA, the carrier has certain responsibilities. It must exercise due diligence to ensure that the vessel is seaworthy, including the requirement to properly man, equip, and supply the ship. It must properly load, handle, stow, carry, keep, care for, and discharge the goods. And one of the big requirements, and this is also a requirement for Carmack, is it must issue a bill of lading. Under COGSA, the bill of lading must show the leading marks necessary for identification of the goods, the number of packages or pieces, the quantity or weight, and the apparent conditions of the goods. And similar to Carmack, COGSA does have a prima facie showing to establish liability. So when and the same principles that underlie Carmack, apply equally to COGSA, namely that a shipper is not present during the carriage of goods, therefore holding the shipper to this to the standard of demonstrating negligence is quite unfair, especially now when you have multimodal transportation, where it's difficult to discern whether the damage occurred while a particular container was on a ship, when it was transferred to the rail leg, when it was then transferred to the motor carrier leg, the semi-tractor trailer. It would be difficult and, in fact, impossible for a shipper to be able to demonstrate where the goods were damaged, how the goods were damaged, what acts of negligence led to the damage, and therefore, similar to Carmack, you see that all that a carrier must do to demonstrate a prima facie showing is demonstrate that the receipt that the carrier received the goods in good condition, and that they failed to deliver the goods in the same condition which they were received. Similar to Carmack, once this prima facie showing is made, then the burden shifts to the carrier to assert a defense to liability. And similar to Carmack, there are specific time limits that one must be aware of in COGSA. Now, these are actually a little bit shorter, shorter by actually half. So suit must be brought within 1 year after the delivery of goods or the date when the goods should have been delivered if lost. COGSA has a very specific limitation of liability. As I mentioned in Carmack, the carrier must provide varying levels of liability. However, under COGSA, there's a very favorable liability limitation, which is the limitation may be $500 per package. The shipper still has the option to avoid the limitation by declaring excess value. Again, this would require the shipper to know that they must do that. The law tends to not be super favorable about really making a situation where the shipper has complete informed decision making. But that's beside the point. So there's also one of the most difficult issues to overcome often is what is a package. The definition is a class of cargo irrespective of size, shape, or weight to which some packaging preparation for transportation has been made, which facilitates handling, but which does not necessarily conceal or completely enclose the goods. This can be very difficult to determine because often any particular shipment is going to be several packages. For instance, it has been argued, and this argument rarely succeeds, that the entire container, those big containers that the cranes move from the ship to the train or to the semi-tractor trailer, is a container, and so $500 applies to the entire container. That generally isn't upheld, but then you have questions as to whether perhaps the pallet, the container has many pallets stacked within them. Is that the package? So each one of those pallets may be reimbursed for $500, or is it the individual packets that are within the pallet? This is all going to be very much a factual determination, but when you're dealing with a $500 per package limitation of liability, this is going to be something that you're going to want to investigate. You're going to want to see how the case law within your particular jurisdiction is going to treat this. This could very well mean the difference between a $1,000 recovery and $10,000 to $20,000 or more recovery. What you're going to want to look for in this particular case to determine whether what the parties understood the package to be is largely going to be controlled by how these packages are identified in the bill of lading. But you'll also want to look at case law in the jurisdiction where a suit would be brought to see how the courts treat packaging. The HIMALAYA clause, we've referenced this a few times. This is the COGSA limitation of liability provision. Generally applies only to carriers and ships. However, through a clause in the bill of lading commonly known as the HIMALAYA clause, COGSA can be extended to non-carriers, carriers, agents, servants, and independent contractors. So for instance, your stevedores. But as I had mentioned before, this can also be extended to the inland portion of an ocean voyage. The reason why the courts do this is that an essentially marine shipment should be covered by one set of laws that everyone can agree to abide to. To effectively limit liability, the clause must be drafted with language. However, this HIMALAYA clause providing the COGSA limitation of liability to parties other than the ocean carrier. It must be drafted with language expressing a clear intent to extend benefits to a well-defined class of readily identifiable persons, and the clause will be enforceable only by members of that well-defined class. So, for instance, if you do have a claim, you'll want to look at the bill of lading if you can demonstrate that perhaps the goods were damaged in an inland portion to see if the clause, the HIMALAYA clause, was drafted sufficiently. So, for instance, it would be clear if the goods were damaged in a semi-truck accident where perhaps the driver fell asleep at the wheel. You would be able to demonstrate that the damaging event occurred on the inland leg, but to get around the $500 package limitation, which could be very unfavorable, you would want to look and see whether that HIMALAYA clause was drafted sufficiently to extend the benefits to the inland carrier. COGSA also permits foreign jurisdiction clauses, which can be somewhat problematic. Through the bills that provide venue rules in the foreseeable event that cargo is damaged during carriage, these foreign jurisdiction clauses will be enforced unless it imposes a venue so gravely difficult and inconvenient to the plaintiff that the plaintiff will, at least for practical purposes, be deprived of his or her day in court. For instance, if the foreign jurisdiction clause chooses a venue that perhaps doesn't recognize subrogation, you could make an argument that it was gravely difficult and inconvenient. However, the argument that the jurisdiction is simply far away from the shipper tends not to be sufficient to overcome a foreign jurisdiction clause. So that's always something to keep in mind. Where are you going to have to litigate it, and whether it's cost effective to litigate cargo loss if the foreign jurisdiction clause is in a country quite far away from where the insured and the carrier is located. At this time, I will go ahead and announce the winner of the trivia question, which is Karen Tucker of Cincinnati Insurance Company. Congratulations. You can, we'll be in contact with you to determine which of the 4 MWL books you you would like to have for everyone out there who was curious at all as to what the answer to this question was. The word semi is from the Latin meaning of half. It references the trailer, not the tractor. The term semi stems from semi-trailer, meaning that because the trailer only has wheels on the back half, it is a semi-trailer. A semi-trailer truck refers to the tractor that pulls the semi-trailer. So congratulations on that. At this time, we can actually, there's one more thing that I wanted to go into, and it's not in our presentation, but it's something that I think for practical purposes bears mentioning, and that is investigation. What to get from the parties, what to get from your insured. The insureds often have a wealth of documentation and information that unless you ask specifically for the particular documentation, they might not know that it's relevant. For instance, I've had claims where an insured took pictures of the cargo before it left their possession, demonstrating that it was in good condition when the cargo arrived. It apparently had fallen off. It had fallen off the trailer. It had been repackaged into these other different packages, and they were these computer monitors that were all busted up. And the photos the insured took clearly demonstrated that previously there were 2 distinct packages, and then they arrived in 4. So the documentation that you want to obtain, number one, is the bill of lading. That's going to be what really controls your litigation. And that's going to be your inland bill of lading, your ocean bill of lading, airway bills. We didn't get into air cargo again due to the limited time we have here. You'll want to get the shipper's commercial invoices and the accompanying packing lists to demonstrate what the value of the cargo is. Any delivery receipts with proper exceptions, notations for loss, damage, notice, and any other exception or bad order slips which may substantiate the loss or damage. Typically, the consignee or whoever receives the goods, if they notice that the goods are damaged, will be making a notation on that bill of lading. So you'll want the original bill of lading and then the bill of lading which the person receiving the goods made the notation that they arrived in poor condition. That's going to help you establish your prima facie case. Trailer interchange receipts for containerized cargo is also good. Any confirmation of non-delivery, itemized claim statements, and any repair or expense bills for damaged cargoes. So at this time, we can start taking questions. Okay, and let me see. Okay, so it looks like our first question is from Sandra. And this question is there any way to get around a limitation for liability for a Carmack claim? Well, you know, as I mentioned previously, in many ways what Carmack gives, it also takes away. And it can be frustrating to have a law that virtually imposes strict liability when it comes to the ability to prove a claim, yet limits the recoverable damages to what amounts to pennies on the dollar. As we discussed, there are 4 elements for a limitation of liability to be upheld. And I think we touched on this a little bit, that the best element to attack is whether the carrier truly offered the shipper a reasonable opportunity to choose between one or more levels of liability. there was a recent Third Circuit decision, and I believe it's unpublished, which has opened the doors in many ways to attacking this reasonable opportunity. Because when you really think about it, having the reasonable opportunity to choose between two or more levels of liability, this idea that simply having one sentence in the bill of lading that refers the shipper to a separate tariff that they must look up doesn't quite seem fair. And what this Third Circuit Court did was it found that no reasonable opportunity to choose between two levels of liability were given to a commercial shipper on this website shipment. I believe this is the Donna Karen case. And there were a couple of reasons. The main reason was that the levels of liability were virtually ambiguous. The website was somewhat ambiguous. The website, if one declared value of a shipment and did not go with the released rate, which I think was 50 cents per pound, the contract of carriage was no more expensive than it would have been if it was at the released rate. But moreover, by looking at the tariff referenced, by looking at the tariff that the motor carrier had, the choice of levels, the choice between levels of liability was simply a 50 cents per pound versus the option to choose insurance and the excess of $25,000. And so in this particular case, the court did find that the limitation of liability did not meet the four elements required and therefore was inapplicable. And so at that point, then the court's decision went into determining what the recoverable damages was. And because obviously the shipper had not declared a value, but still the limitation of liability was overturned. So these are going to be the types of issues that you're going to look at. You're really going to want to scrutinize the tariff. You're going to want to scrutinize the bill of lading, and even the manner in which the shipper chooses to select whether they're going to declare a value or go with the released rate. As I said, I don't believe that this is a published case. It was in the last few years, but it certainly, depending on your jurisdiction, could be cited for persuasive value. The next question is from Gary, and this says, does Carmack apply to shipments if the start and end point are within the same state? Well, actually, I probably should have addressed this earlier in the presentation. The simple answer to this question is no. Carmack is for interstate shipments. So that's going to be one of the first things that you're going to want to look at when you're determining whether Carmack applies to your particular shipment. But theoretically, even an interstate shipment where the point of origin and the destination are within the same state, Carmack could apply if, for instance, the motor carrier had to leave the state and then re-enter. How often this occurs, I'm not really sure, but I believe at that point, if you just have a completely intrastate shipment, shipment occurring only within one state, I believe at that point your remedies are state law. And let's see, it looks like we are actually out of time for questions. As I had mentioned, if I did not have the opportunity to get to your question during this webinar, we will go through them and answer them by email. I really want to thank everyone for taking the time out of their day to to attend this webinar. I hope it was helpful, and certainly we can, if you have more specific questions, we can answer those at a later time. I know this was very, very introductory, just the basic highlights of what the laws are, what the options are, how to establish liability, what the limitations on remedies are, et cetera, et cetera. So thank you, and enjoy the rest of your day.